Welcome to Critical Thinking on Gay TV on the Go. I'm your host, Waymon Hudson, and each episode we'll be bringing you in-depth discussions with newsmakers and opinion shapers on all things political in the LGBT community. On this edition of Critical Thinking, I'll be breaking down the arguments and possible outcomes of two historic marriage equality cases heard by the Supreme Court. The first case is Hollingsworth v. Perry, which challenges the constitutionality of California's Proposition 8 that banned same-sex marriage. The second case is United States v. Windsor, which argues against the constitutionality of Section 3 of the Defense of Marriage Act, which defines marriage as one man and one woman for federal recognition and benefits. As we look at the oral arguments in the cases, it is worth noting that the tone of the questions don't necessarily show exactly where a justice will come down in the final decision of the court. The Supreme Court heard the oral arguments in Hollingsworth v. Perry, the challenge to the constitutionality of California's Proposition 8. Prop 8 was the California ballot referendum passed in November 2008 that banned same-sex marriage, reversing by popular vote the state Supreme Court's decision just months earlier to recognize marriage equality. The argument came down to two questions and two main issues: whether the proponents of Proposition 8 have any legal standing to argue for the ban, and the actual merits of whether Proposition 8's ban on same-sex marriage is constitutional. A large portion of the Prop 8 oral arguments focused on the issue of standing, which simply asks if the Proposition 8 proponents have a legal right to be in the case at all. California officials declined to defend Proposition 8, so 5 proponents of the law stepped in to argue for it. The majority of justices seemed skeptical about whether they should be hearing the case at all. Several justices, including the liberal bloc, swing vote Justice Kennedy, and the conservative Chief Justice Roberts, seemed to think the proponents had no personal injury at stake, and thus no standing to sue. Charles Cooper, the lawyer for the opponents of same-sex marriage, responded that injury is to the state. On the actual merits of the case, several key issues were argued. In perhaps the most important moment of the oral arguments, Justice Kennedy, the likely critical swing vote in both cases, showed that he had real concerns about the over 40,000 children being raised by same-sex couples in California and the impact a marriage ban had on them.
There is an immediate legal injury or what could be a legal injury, and that's the voice of these children. There are some 40,000 children in California, according to the Red Brief, that live with same-sex parents. And they want their parents to have full recognition and full status. The voice of those children is important in this case, don't you think?
Another key moment came from Justice Elena Kagan over the proponent's argument that the state has an interest in responsible procreation. Kagan pointed out that there are many opposite-sex marriages granted to which procreation is unlikely at best, like when opposite-sex couples over the age of 55 get married, saying,
"I can just assure you, if both the woman and the man are over the age of 55, there are not a lot of children coming out of that marriage."
Conservative justices also pushed the pro-equality lawyers during questioning. Chief Justice John Roberts suggested that California had already gone far enough in providing equal rights to same-sex couples with civil unions, arguing that the word marriage was really just a question of labels. Justice Samuel Alito asked whether those favoring marriage equality were asking the court to jump into uncharted territory, claiming same-sex marriages were newer than cell phones and the internet.
But you want us to step in and render a decision based on an assessment of the effects of this institution which is newer than cell phones or the internet? I mean, we do not have the ability to see the future.
The Supreme Court took up the case of United States v. Windsor, which challenges Section 3 of the Defense of Marriage Act, a law which bans federal recognition of same-sex marriages. The case was brought by Edie Windsor, who was widowed when her wife, Thea Spire, died in 2009. Windsor was forced to pay over $300,000 in taxes on Spire's estate due to DOMA's ban on the federal government recognizing their legal marriage as the same as an opposite-sex couple's for tax purposes. Had Windsor and Spire been opposite-sex spouses, she would have been exempt from that tax. The main issues in the arguments came down to 3 things: legal standing, states' rights to define marriage, and equal protection for same-sex couples. Once again, the issue of standing came up in the case. The Obama administration declined to defend DOMA, agreeing it was unconstitutional, yet still enforcing it, which Chief Justice Roberts called unprecedented. So at the instruction of House Speaker John Boehner, the Bipartisan Legal Advisory Group, or BLAG, took over defense of the law. The question of standing came down to whether BLAG had the legal authority to defend a law when the president himself refused to defend it. On the merits of the case, it quickly became clear that DOMA was in trouble on many levels. Likely swing vote Justice Kennedy cited the over 1,100 federal laws that the Defense of Marriage Act affects, noting that the federal government is intertwined within citizens' day-to-day life.
But when it has 1,100 laws, which in our society means that the federal government is intertwined with the citizens' day-to-day life, you are at real risk of running in conflict with what has always been thought to be the essence of the state police power, which is to regulate marriage, divorce, custody.
Justice Stephen Breyer pressed BLAG lawyer Paul Clement on whether DOMA had any rational basis, an important legal test for laws that discriminate against a specific group of people. Clement argued unconvincingly that the need for a consistent federal policy was justification.
All right, so you're saying uniform treatment's good enough no matter how odd it is, no matter how irrational. There's nothing but uniformity. We could take no matter. You see where I'm going?
Perhaps the most memorable moment came from Justice Ruth Bader Ginsburg. Focusing on the equal protection argument, Ginsburg asked Clement about the vast benefits denied same-sex couples under DOMA in what has come to be known as the skim milk marriage moment.
As Justice Kennedy said, 1,100 statutes, and it affects every area of life. And so you would be really diminishing what the state has said is marriage. You're saying, no, state, there are two kinds of marriages, the full marriage and then the sort of skim milk marriage.
Justice Elena Kagan focused on the red flags and underlying motives of Congress in passing DOMA, asking whether the judgment was infected by dislike, by fear, or by animus. She cited a House DOMA report saying,
well, is what happened in 1996, and I'm going to quote from the House report here, is that Congress decided to reflect and honor a collective moral judgment and to express moral disapproval of homosexuality. Is that what happened in 1996?
Conservative justices focused on the sea change in public opinion on same-sex marriage, seeming to try to conclude that gays couldn't possibly be powerless and discriminated against. Chief Justice Roberts suggested that this was the result of a political power shift, while pro-equality lawyer Roberta Kaplan maintained the shift was about a growing understanding of gay people and their relationships.
I think with respect to the understanding of gay people and their relationship, there has been a sea change, Your Honor.
While many in the media are already speculating about the outcome of the cases based on the questions of the justices, it should be said that the High Court often asks tough questions of both sides in any issue. With that in mind, let's look at some of the possible outcomes for each case. In the Prop 8 case, there are a number of ways the High Court could decide. The most unlikely would be for them to affirm Prop 8 as constitutional, meaning California would remain free to ban same-sex marriage. To be perfectly clear, this is by far the least likely outcome. What many legal experts seem to think is far more likely is that the Supreme Court will punt on the broader issue of the freedom to marry and decide on the issue of standing. If the court decides that the supporters of the ban lack standing to appeal, this would mean the lower district court's ruling against Prop 8 would stand and marriages in California alone would resume. Additionally, a legal question still remains on whether the ruling would only apply to couples in the case or whether Prop 8 is dead statewide. That might take even more litigation to determine. The court could also strike down Prop 8 in many different ways, with varying effects around the country. They could decide California was not entitled to withdraw a right to same-sex marriage once it had been established by the California Supreme Court, which would allow same-sex marriage in California but keep marriage bans in other states. The court could also decide that California was not free to provide same-sex couples with all the benefits and burdens of marriage through civil unions, but withhold the label marriage. This would affect not only California, but the 8 other states with everything but marriage civil unions. In the broadest decision, the Supreme Court to decide all bans on same-sex marriage violate the Constitution. This sweeping decision would mean all laws prohibiting same-sex marriage around the nation would fall. In the Defense of Marriage Act case, there are again multiple complex options for the court to base its decision on. Almost all analysts, court watchers, and pundits agree that the chances of the court upholding DOMA as constitutional is virtually non-existent. Almost equally unlikely would be for the court to decide that it lacks jurisdiction because the two sides, the plaintiff and the Obama administration, agree that the law is unconstitutional, and House Republicans don't have the standing to defend it. It then comes down to how and on what grounds the court strikes down DOMA. There do appear to be enough votes to find DOMA unconstitutional, with some justices finding it violates the Equal Protection Clause of the Constitution, and others, perhaps Kennedy, finding it's a federalism issue, meaning that marriage should be left up to the states. The immediate impact of finding DOMA unconstitutional is that married same-sex couples in the 9 states that allow marriage equality, along with the District of Columbia, gain the more than 1,100 federal benefits that come with marriage. While this ruling has no direct effect on states with no marriage equality, it does set up further legal challenges by once again treating same-sex couples differently when it comes to benefits depending on the state where they live. While we won't know the outcome of the cases until late June, one thing is clear: momentum for equality is on our side. These historic cases, the groundswell of public support, and the quick movement by politicians to the pro-equality side show that the arc of history is bending towards justice. But to be clear, our work is far from done. We must continue to educate, agitate, and advocate for full equality, whether it be full marriage rights or employment discrimination protections or transgender equality. Continued LGBT visibility and activism, a common theme in the court cases, has truly changed hearts and minds at a rapid pace in this country, and it can continue to push us forward in our civil rights struggle as we fight for a more perfect union. And that's Waymon's wrap-up. You can join our discussion and ask me questions on Twitter using the hashtag CriticalThinkingTV and on our Critical Thinking Facebook page, where you can see exclusive behind-the-scenes photos and information about our show. And be sure to join us here on Gay TV on the Go for new episodes of Critical Thinking, as well as great shows for the LGBTQ community. As always, I'm your host, Waymon Hudson, reminding you that when it comes to LGBT politics, you can always use a little more critical thinking.